Back on the record in case of People's State of Michigan versus James Whitley. Typically, oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett, appeared with me, Mr. Whitley, sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that, unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, so at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings, and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point, to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern.
I'm not asking for your concern. I'm asking for, you have made an accusation that, no what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam, that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
There were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable, because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss a recanted note with the alleged victim, I said, why we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Does that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it set?
because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Misuse.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. But I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. That behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. and quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss. And you.
I did not.
If you start this exam, she's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this threat.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule?
Well, this case was different because this is not a situation where, this is a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him with the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Sabat.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, you know.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice. Not just with me, but with your ticket to practice. Court's in recess. All rise. Back on the record in the case of the people, State of Michigan versus Whitley, counsel is present as well as the defendant. there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you, in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now, knowing it, as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification, and I would...
As to identification of...
the defendant. So it's very brief, and I don't want to have to bring the lay person back.
Understand. Mr. Bennett.
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only...
July 1st at 10 a.m.
I realize that gets close to a holiday, but will that work?
Yes. Thank you.
Oh, that's fine. I will adjourn it. Mr. Bennett, please apprise this office as well as the prosecutor if you're going to self-report, so that maybe others of us don't have to take any action.
Yes, Your Honor.
Preliminary examination in this matter is adjourned.
Buckle up, guys. Today we're going to break down a courtroom moment where tension doesn't slowly build. It detonates early. From the very first seconds back on the record, the judge signals that something unusual and serious is unfolding. This isn't about routine procedure. It's about conduct, power, and perceived threats inside a courtroom. The judge openly discloses a bench issue, which alone tells you this crossed the line. Defense counsel has floated the idea of grieving the elected prosecutor for simply doing her job, and the court immediately frames that as dangerous territory. The language is careful but pointed. Chilling effect. Interference. Grievable offense. You can feel the judge asserting control, drawing a bright line around acceptable advocacy. This introduction isn't just scene setting. It establishes that professional ethics, not evidence, are about to take center stage, and someone's judgment is already under scrutiny. The judge now forces the issue into the open, pressing defense counsel to stop circling and state his accusation clearly. This is where vagueness collapses under pressure. Mr. Bennett tries to soften his position, walking back the word grievable, even as he explains why he used it. He frames his concern as ethical, not aggressive, pointing to a recanted statement and the possibility of prosecuting an innocent person. On paper, that sounds noble. In practice, it's shaky. He admits he suggested adjourning the case, so the prosecutor could speak to the alleged victim again, implying a failure to investigate. The problem is timing and tone. The judge isn't buying the backpedal, and the subtext becomes obvious. Raising ethical alarms inside a courtroom is one thing. Implying professional punishment if the case proceeds is another. This part exposes the gap between intent and impact, and the court is already focused on the impact. This is where the prosecutor steps in and the narrative begins to flip. She states plainly that she intends to proceed under the statute and denies any misconduct outright. The judge sharpens her questions, suggesting that the defense's accusation itself may amount to obstruction. That's a serious escalation. Bennett attempts to retreat into legal theory, invoking confrontation clause issues and evidentiary concerns, but the explanation doesn't land. The judge keeps drilling one point. How does following a statute and court rule become an ethical violation? Bennett struggles to connect the dots, repeating concerns without anchoring them to actual misconduct. As a third-party observer, this is the moment where the defense position starts to unravel. What was framed as protecting fairness now looks like overreach, and the judge's patience is visibly thinning as the argument loses coherence. Here, the courtroom temperature spikes. The judge abandons hypotheticals and speaks in absolutes. She makes it clear that no lawyer, defense or prosecution, will ever be intimidated in her courtroom by threats to their profession. Then she calls the behavior what she believes it is: inexcusable and sanctionable. This isn't a legal debate anymore. It's a disciplinary lecture. Bennett insists he never intended a threat, but intent no longer matters as much as perception. The judge repeats that threatening someone's livelihood, directly or indirectly, is unacceptable. Each exchange tightens the vice. From an outside perspective, this is the turning point where authority fully asserts itself. The judge isn't asking for clarification anymore. She's drawing boundaries, and Bennett is standing on the wrong side of them. The discussion shifts from accusation to consequences. The judge dismantles Bennett's assumptions about the prosecution's investigation, while the prosecutor places concrete facts on the record that contradict his narrative. That contrast matters. Speculation versus documentation. The judge then delivers the warning that changes everything. She may have to consider grieving him. That's no longer theoretical pressure. It's real. She pauses the proceedings with a recess, explicitly telling Bennett he is on thin ice. Not just with her, but with his ability to practice law. From a third-party lens, this is the courtroom equivalent of a red card. Whatever Bennett's original concern was, it's now overshadowed by his own exposure. The power dynamic is fully reversed when court resumes. The tone is quieter but heavier. Bennett announces he will self-report and apologizes, acknowledging the message he sent was inappropriate. The judge accepts nothing lightly, still labeling the conduct a threat and reserving her right to act. Yet the court pivots toward resolution, moving the case forward despite the disruption. A stipulation avoids unnecessary testimony. The preliminary exam is adjourned, and a new date is set. Its procedural closure layered over professional fallout. The lasting impression is clear. This hearing will be remembered less for evidence and more for boundaries enforced. Advocacy has limits, and crossing them carries consequences. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.